Matthew McConaughey goes live on CNN this past Saturday and says AI is coming. There's too much money to be made. First thing you should do is trademark yourself, own your IP. You are IP. And the reason why he says this is because then if people want to use your name, image, likeness, then you can actually sell it back to them at your own price. So I have Katie here. Katie, we just watched the clip pre-show. Of course, this video went viral. I saw it all over the world many, many times. Everybody resharing it. They leaked out this part, and then sure enough, the full conversation was on 7 p.m. on CNN. Why do you think he's going live with this? Is he one of the smart whistleblowers for his industry? Let's just unpack this, Katie.
Yeah, I think the reason he's going live with this now is we've seen such an uptick in AI being embraced by everybody. And I even saw, I think it was earlier this week, there's going to be a new Apple device coming out that's basically a circle that sits on your clothing and records everything your whole day. And so as these tools become more accessible, more publicly accessed, there's so much more fakes, right? And ripoffs of modern day tech through them, because even we've seen, for example, the Anthropic book stealing case, right? Where the AI is scraping all this protected IP and they're not taking a license to the IP. And so they're directly infringing the IP. So the same thing along that line is what he's trying to get at here, that as IP and these tools record your voice, record your style of writing, all of these kind of human attributes that they start to replicate, that's protectable IP that you can then enforce. But I think the bigger thing here is about control. When it's your human attributes, you want to be able to control who can use them and how. So that's a way, by protecting them, you maintain all that control, and you can of course sell it, license it, do whatever you want, but you get the final say in it that way.
I love that. And this came out, I'm going to bring the article up, just 72 hours ago, that one of the AIs created, I want to get this fact check it exactly right, but I want to say it was like 16,000 fake accounts, stealing another AI model's prompts. Okay, so did you? I don't know if you heard of this one, but literally people are saying it's the AI Cold War. Have you heard about that?
No, that's interesting that there's theft in the prompts for the AI models.
Yeah, I'm gonna bring up the article. This is starting to hit everywhere now. It's called the AI Cold War. U.S. tech companies accuse China's AI firms of stealing billions in research. And so, yeah, United States and China race to develop AI. American firm Anthropic is the latest company to sound the alarm that Chinese companies have been stealing 16 million conversations using 24,000 fake accounts to harvest. So you gotta think about this. I know there's a little bit of irony here. There shouldn't be, but Anthropic stole my book and 500,000 others. Now they're mad that other people are stealing from them. But I mean, this is so nutty that now these other three are essentially, again, it's not just me, but essentially they're now stealing me and the 500,000 other base authors.
Yeah. When I think too, what's interesting is that there's been a lot of news stories lately about these large language models, these AI bots, right? That people are having these very personal conversations with it, right? They're uploading their medical records, they're asking it, questions. And
Yes.
so it's also, there's all this the reason too, I think this is so important is because the data that's getting collected in them has such a high value.
Yeah.
And it's so, deeply personal, right?
Yeah.
And it's like, things of, I want to quit my job. What should I do? It's like
Yeah.
almost a
It's
peek
like
into the
trade
future.
secrets or something. Yeah.
Yes, exactly. And I think too, it's interesting how some of these are also being used to implement people in crimes, right?
Ah.
Kind of, we saw a few years ago, there was a big case in Massachusetts about the girl who sent the text message to the boyfriend to when he was about to commit suicide, telling him to just do it. And so there was a lot of case law around
Really?
would that implement, a guilty verdict because there's all these text messages encouraging him to do it. And I think the same
Wow.
kind of thing could be translated over here, right? With these models. And you can also, if you've done all this searching on how do I, bury a body, right? Or all these weird things, it can also start to implement you in these criminal activity too.
Yeah. Yeah. No, 100% on that. I feel like it is a new world that we're
It
living in.
is.
And it's almost like these movies about Minority Report and years ago. I don't know if you remember Minority Report, but basically you could be accused of a thought crime.
Mm-hmm.
So Tom Cruise and friends would basically be able to see the future and arrest you before you actually had done the act. And I feel like you're almost bordering on that with this. I'm thinking about it. I'm thinking about it.
Right.
I'm talking to my chat. I'm talking to my AI. And now all of a sudden the AI is like,
Right.
and it goes back to the whole abracadabra, I create as I speak. I mean, now you're being held accountable to crimes that you just thought.
Yes.
Yeah.
And I think too, it's interesting, a client this week was asking me about IP ownership when you put something into Chat GPT and these kind of large language models. And what's interesting is that they say you own the input and the output, but they can make no guarantees that the output doesn't infringe on somebody else's IP.
Where
And so
do you have that somewhere?
It's in an agreement, like a term of business when you have a business account with them. And so I think that's interesting because then they also disclaim liability on their own behalf if the output infringes it. So, I think it's really interesting because a lot of people are using these tools too to generate IP. And so, you have to be very careful with the IP that you do generate, how you go about protecting it. And there's some, forms of IP, like in the US, copyright, you can't have a non-human author register a copyright too. So there's also that layer as well of if you do create IP with AI, is it even protectable as well?
But see, that's we get this question all the time about instant IP, and I tell people like it's on you if you put in some kind of question and they like this is the whole TEDx theft that happened to me.
Yes, exactly.
The guy says, "Hey, write an article on AI and IP," spits out my TEDx, posts it, and who knows if it's true, but he said he had no idea that it infringed. But, I tell people on the other end, if you're going to chat and you're having all this happen, it's on you. And that's what you're saying. It's on you.
Yes. Well, and I think what's so interesting in that case that happened to you with the IP theft too is the whole entire TEDx talk was verbatimly put into the article, right? It wasn't just bits and pieces of it. What's interesting is the whole thing was replicated
Absolutely
in his article. And I think that's also a major blind spot of this technology right now, is that you have, even if it produces something for you,
right.
You have to take the step to check the authenticity of it, because some of it is, just inaccurate because of the
Absolutely.
posting and the issues there, but also some of it could be somebody else's IP. And so you have to really do a deep dive on that as well.
Absolutely. I agree. And that's the danger you play when you think, oh, I'm just going to create all kinds of IP with AI. This is bringing us into a couple other issues, Katie, that I have questions about. One, I want to show you an example. I subscribe to a certain person's newsletter, and I blocked out their name so that they are not in trouble. But basically, this is an example that you've heard me talk on. Oh, hang on. I'm lost here.
Oh, yeah, we lost your video there for a minute.
Okay, here we are. Okay. I'm trying to bring this up on the screen. All right, here we are. This person sent this out. Okay. Now I crossed out the whole thing so you can't tell who it is. But basically, they sent out an email that said, our speed to value advisory and executive sessions are blah, blah, blah. And they put a TM. And anytime I see a TM, I'm like, oh my gosh, I'm excited. Is this IP? It just signals. It's a signal to me. And don't you think it's a signal to everybody? Otherwise, you wouldn't use it.
Right? Exactly. Right.
A TM is a signal. So I went, Katie, and I thought, you know what? I care about this person. They're an instant IP user. And I'm like, why are they not using a superscript? Number one. Secondly, I'm going to go to the USPTO and see if speed to value is actually registered with them. And I went to the USPTO and I typed in speed to value. And in the same class, it's registered to someone else. And I quickly went back to this friend and I'm like, friend, you got to be careful, because now you're sending out an email where you're putting a TM on someone else's registered term in the same class.
Yeah.
I mean, let's talk about that for a second. I know this is not legal advice. This podcast never is, but we talk about very relevant things. But don't you agree that that is part of the problem?
That is, I'd say the interesting thing, I think, to ask that person is when they first started using that mark, because if it predates use of that registered mark, their first use, they might have some geographical rights to use it if their use predated it. Now, if it doesn't, then that is a bigger issue, and they're probably going to be sent a cease and desist letter if this other company is monitoring infringing use. So it's something to definitely be concerned about, and to probably, get some legal advice on as to how to kind of clean it up a bit there.
And if they had used instant IP, and if they had, for this term, and if they had predated the other people who submitted a trademark, the beauty of instant IP is they could literally take it down to the second and say, here, on this day, we started using it. We put it in a smart contract. We do view it as IP. It is serious. And now it's not disputable of like, oh, well, I kind of don't know. Maybe it was a brochure. I don't know. Don't you agree?
And this happens all the time because, even trying to get, some clients, maybe they started using the mark 20 years ago, right?
Yeah.
And so it's trying to dig through paper files to find proof to submit to the USPTO to prove that use. And it can be hard to go find receipts, find marketing material, whatever. So this becomes a huge issue. And that's why if you use a tool like Instant IP, where you have this timestamp, it's immutable, it's easy to access and show the use, that just makes it so much easier, because
Yeah.
when you do submit your federal registration, you have to submit the date of first use and evidence of use. So anything to kind of streamline the process, but also make it irrefutable like that, I think is such a powerful tool.
Absolutely. I think that's huge. And time is money in the legal world. So to have to go back and look through all kinds of receipts and all this stuff takes time for the CEO. It takes time for the
Yes.
law firm. Yeah.
And or it's like, oh, that was maybe on this computer in some file, and the computer's now dead. So now we have to pray we can revive the computer. It just creates so many hurdles that are unnecessary too.
Well, and that's why I wrote this article, 7 Reasons to Think Twice Before Using a TM symbol. It's not that I say you don't ever want to use it, but I say you want to use it when you have filed a registered trademark, because then it actually shows, hey, there's some timing behind it. Otherwise, you get into this whole thing of, hey, who is the owner, who's not? It's like the example of I might have locked the door,
right,
but I'm not sure. There might be a deadbolt. Wait, the security camera might be on. Who knows? And then that confidence gets shot. And then right here, a competitor, it invites infringement. It almost tells your competitors, hey, I think this is important, but I haven't done anything about it. So basically, you're basically pointing the value in your company, but you're saying, but I put no boundary around it. So have at it. We've talked about then they can run, grab it, and potentially file. Now you're in trouble. And then this is that culpability thing. You might not be the first. Speed to value isn't, he's not. So again, like, I'm not against TMs. I use them when I have filed a trademark and I'm waiting. I mean, I know this is not legal advice, Katie, but do you think that that's probably the best time?
Yes.
Don't just throw TMs on everything.
Right. Well, and the thing is too, in the past few years, the USPTO has gotten a lot more stringent on confusingly similar, right, marks. Yeah. And so we've seen this happen a lot, where even if you do a little bit of searching and it looks okay, the USPTO will cite tons of these other marks, right? And it can be a real uphill battle to try and overcome some of those rejections. So that's where too, I think, as part of the strategy, doing some searching, figuring out what else is out there, and then protecting it, right? Filing the registration and then using the TM while you're waiting for the federal registration to get approved. It's a smart strategy that, we can never fully search on everything, predict the future, or know exactly what the examiner is going to cite, but it at least helps you do as much of the diligence up front as you can anticipate to.
Absolutely. And even the fact of, rebranding, right? Now I have Instant IP and we've registered it. But prior to that, we had registered a different name, granted it, but during the oppositional period, a multi-billion-dollar company comes out of the woodwork and says, hey, that's ours. And the cost of rebranding, we're talking new domain names, new shirts, new literature, even just the customer mental power of like, wait, I thought this was your company. Now, wait, hold, you lose some credibility and brand equity.
Absolutely. Because then too, you've built up a lot of consumer recognition of that original brand. So to then have to transfer that consumer knowledge and recognition over can be very difficult and challenging too, because you're kind of starting from scratch again. You know, you're trying to put out press releases.
Yes, that's
tell
what we did.
everybody there's this new branding, but it kind of takes time for that to build up too.
Absolutely. Last few minutes, we'll do speed round here. This is interesting, Katie. I just got this. Chad Jenkins wants to record your upcoming meeting. Fathom has now put, before a meeting even shows up, are you going to give consent? I think this is that whole Apple device thing coming. You know, I've talked about it with that recording device that is very common and probably going to hit in 2026 throughout the whole psyche, is just like everywhere you go, you are being recorded. What do you think about that? I mean, why is Fathom sending this out before a meeting even exists? Are they protecting themselves?
Yeah, good question. So someone in the legal department, you know, clients probably hate me for this, but I never allow those recording devices into meetings.
Yeah, that's all right.
Because it creates serious questions about the confidentiality and privilege of the attorney-client discussion. Yeah. So I would never want to risk that. And I think too, it just makes you a sitting duck for potential liability later on. Because if, let's say, I'm talking to a client about a competitor, right? And then this recording is leaked years later in a lawsuit, it could be very damaging to the client. So it's something I just don't, I'm doing it for the protection of the client, but I understand, why people would want to use it. CEO, right? People are busy. And so it's like an organizational tool that helps keep them on track, right? So I totally get it, but I think there's a fine line and a balance there too.
Oh yeah. No, I think you're right onto it. I think there's pros and cons.
Right.
Yeah, definitely. Last thing for today, I want to read this to you. I'm not going to show you their face because I don't want to get them. Again, I always protect people's confidence here. Chad Jenkins is different. He wouldn't care. But this other person, let me just tell you what it says here. Hey, Carrie, I'm excited about our upcoming webinar with Instant IP for my musician and artist audience. When registering with Instant IP is $97 versus a US copyright $45 to $65. I know that the question is coming up. Typical musicians write their songs, register with their distributor, the US copyright, other royalty companies. Will this replace the copyright Instant IP? Why or why not? I'm going to tell you what I said to this young lady, okay? Here's what I said. Short answer. It's not either Instant IP or a copyright. It could be both and. They can put many songs in one smart contract. In fact, their whole portfolio. It's also extremely fast while they're then waiting for their copyright to get approved. They could upload their whole album. They could upload the music itself as a audio file, not just the lyrics. So in other words, what I'm saying is, look, I'm not saying use Instant IP instead of a registered copyright. You know that I put this on Instant IP, this book, and filed a registered copyright. Meaning, if something's very important, are you just going to be like, oh, let's just put a deadbolt? Or do you say, you know what, that's so important, I'm going to put a deadbolt, and I'm going to have a guard dog, and I'm going to have a security system, and I'm going to have a fence? Like IP stacking. You know, Katie, I did that with Instant IP, like multiple patents, copyrights, trademarks, Instant IP smart contract credits. I mean, if something's that important, don't you think that the more layers you have, because we heard from a musician, I don't have time to file a copyright. I just came out with the song. I don't know the drummer who's sitting in there in the rehearsal room, but we're going on the show on stage tomorrow night. We need to practice. So I'm handing out my lyrics, and if I, don't know the drummer, at least they have it time stamped then, while they're waiting for the copyright. Like, is there any danger of doing multiple layers?
No, not at all. I think it's a smart strategy, and it's one that everybody should consider, because I think it's a common misconception that the book, right, or whatever piece of IP you've produced is only protectable with one form of IP. And a lot of times when you peel back the layers, there's so many different forms of IP that can be protected. Even the book, for example, right? Like you mentioned, the copyright, the instant IP protection, there's a
so many,
trademark in the name of the book, right? And so there's so much, there's patents around the methodology of instant IP. And so I think it's something people miss because they think, oh, like I checked the box, I did that IP thing, I'm done, I never want to think about it again. But it's a process that it's always evolving and it's never slowing down.
So a musician technically could have some new music technology built into the song. I'm sure auto-tune at one point was like the first auto-tune, and now that could have been protected, that new technology. You just got me thinking, Katie. There's a famous guy named Simon Sinek who wrote a book called Start With Why. I'm sure a lot of people have heard about it. But he went and this dude gets $150,000 to talk on this at corporations. So yes, this is part of the book, but guess what he did, Katie? He took this, named it the Golden Circle, and then went and put other layers of protection because he felt like it was that much more important.
That's right. Yeah, I love that name, the Golden Circle. That's great.
Yeah. But like people might be familiar with Working Genius by Patrick Lencioni. It's a book, but it's an assessment, and it's a certification, and it's its own business, but it's all built around the book. But you see, just like what we teach, 18 streams of income, he's turned that book into other forms of IP.
That's right. Exactly. And there's, it's also something you don't have to do all at once either, right? It could be very overwhelming to think, oh gosh, I have to go figure out all this IP protection. It's something, if you're very strategic and intentional about it, you can kind of pace it out as you go to help it, not have to do all of it at once either.
Dude, you got me thinking. I'm so glad we had this chat because I'm going to be on the next week. I'm going to be on with musicians who I don't know. I don't know that craft a lot, but we talk in the book about Taylor Swift. So Taylor Swift, of course, probably copyrights her song. But then if you look at Taylor Swift, you can see my screen. I mean, look at how many times she's trademarked just her name. But then she went into Fearless, Midnight.
Yes.
I mean, this is only page 1. I believe she did like This Sick Beat. So like she's now taking phrases from the songs and saying like, oh, that's so important. I honestly think it is Sick Beat. I think I read that somewhere. Yeah. This Sick Beat, right? So like she went and filed. A lot of them are dead at the moment. But I mean, she absolutely went and said, look, I'm going to put this everywhere. So yeah, that's an example of somebody who treats the whole enterprise as IP and not just, oh, I got a song lyric and I paid $45.
Right. Exactly. Well, and I think too, she's trademarked her album names, Cat's name, the tour names, right?
Yeah.
Everything. And she's put them in multiple classes, right? To protect not only the name itself, but she puts it on t-shirts, flyers, right?
Yeah.
So many different things and strategies to be, we always talk about building the moat around the castle.
Yes.
And I think this is a good example of somebody really doing that to try and make the castle, you know, as foolproof as possible here.
And our quote in the book that we say a lot, because I know what critics are going to say. Hey, but that's Taylor Swift, you know. And our whole point is, I want to show people this. This is right on our page. It says at the very bottom, you don't protect your IP when you're big. You become big by protecting your IP. In other words, the day you start taking yourself seriously over here too, other people take you seriously. So we're not pushing this. I mean, fine, don't do it. But you go through history and you start seeing the people who started to become big took it seriously while they were building it.
That's right. Exactly.
All right, Katie, I got to leave with one thing that I saw cool the other day. Do you know how Transformers protect, how they showed their IP marking on their robots?
No.
So Transformers was big, but then people started to copy it. So then what they did is they put on this sticker that was heat activated, and you would put your thumb over the robot, and then it would show the Transformer symbol. And then they trained all their kids, only real Transformers have this mark. Isn't that cool?
That's so cool. Yeah, I love that.
I saw that the other day. I'm like, that is so good for IP marking. All right, folks, go make it happen. This was a ton of value today. Thanks, Katie, for being here.
Yeah, this was a great talk. Thanks.